Welcome to Dram Shop Laws and Liability, the history of and current legal liabilities surrounding alcohol sales. Dram shop laws are laws stating the guidelines and restrictions on selling alcohol, as well as the kinds of events that an establishment is legally liable for related to alcohol. This can include requiring a license to sell alcohol as well as proper handling, etc. Investopedia states that dram shop laws hold a business liable for serving or selling alcohol to minors or intoxicated persons who later cause death, injury, or property damage to another person. According to 5 centuries worth of history in England, dram shop laws were created as early as the 15th century and were later given their name because a dram was the measurement commonly used for alcohol in the 18th century Britain. These laws were further introduced in the 18th century during the temperance movements that ultimately led to the prohibition of alcohol in the US in the early 20th century. The laws included restrictions on selling alcohol, inability to hold an alehouse license without magistrate permission, or if one was not given recognizances for good behavior. This system also provided penalties in cases where persons sold beer without magisterial permission. Such offenders were to be lodged in the common jail for 3 days and were to give security not to repeat the offense. The innkeeper or owner may even be fined 10 shillings if they were to serve people who were lewd tipplers. Like all legal practices and laws, dram shop laws have evolved and changed over time. To point out these changes, I have a short reading of compiled quotes specifically about them. The original dram shop laws were created in the last year of Edward VI's rule, or 1553. The next act, passed in 1607, was aimed at brewers who sold beer to unlicensed retailers. Such brewers were made liable to a fine of 6 shillings and 8 pence. Accordingly, all and every person convicted of drunkenness was made liable to a penalty of 5 shillings to be paid within a week. If the culprit refused to pay, a distress was to be levied upon his goods. If he had no goods, he was to be placed in the stocks for 6 hours. Furthermore, persons who haunted alehouses contrary to the previous act were made liable to 4 hours in the stocks. In the Act of 1627, corporal punishment was provided for those who had sold ale without a magistrate's license and were unable to pay the fine. After the Act of 1627, more than a century elapsed before Parliament passed another important measure for the policing of the liquor trade. It was an act authorizing the appointment of commissioners to grant licenses for the sale of wine by retailers. There are 2 common instances of dram shop liability today, including first person, where the facility is liable to any injuries or happenstance of the overserved customer due to their intoxication, and third party, where the facility is responsible also for the actions of that customer that possibly cause damage or injury to another separate third party. In the United States, third-party suits are the likeliest to be considered by the legal world, as the overserved person has hurt someone else or done something else to them because of their drunken state, which the shop and/or server would be held responsible for facilitating. Whether the shop is liable for first-party damages depends entirely on each specific state's differing laws. Some states, like Delaware and Virginia, do not enforce liability on the server or establishment for first-party damages or cases, while some others, like New Mexico, do. Some states are also held responsible for first-party suits when the case involves selling alcohol to a minor and also includes whatever damages ensue from that sale. For example, in Georgia, a licensed establishment must have knowingly served alcohol to a minor or visibly intoxicated person to be held liable. For the most part, the current dram shop laws and liability guidelines are positive because they protect hurt third parties and minors affected by overserving and/or negligence of ID checks. They also prevent minors from gaining access to alcohol and may prevent the establishment from undue responsibility, and sometimes provide damages for when servers do not cut off over-intoxicated guests. As a whole, stricter dram shop laws have created a decrease in alcohol-related crime as well. According to Lawrence Greenfield of the U.S. Bureau of Justice, rates of arrest for DUI have declined by 24% since 1990. During the last 10 years, the number of highway fatalities attributable to alcohol-related accidents has dropped by about 7,000 annually, a 29% decrease. However, sometimes these laws can have a negative impact, as one filing a lawsuit may not be entirely sure if their state will take the case and may run into complications. Bars and alcohol sellers may not always be responsible for certain damages, which could be distressing to one attempting to file a suit when they feel they have been wronged, whether third or first party. Be sure to check with a state attorney or look for online resources, such as the one listed here, to ensure you are aware of what damages you may be entitled to, as well as what the dram shop laws are for your specific state. Here we have all of my sources, and these are my citations for my photos.